Good day, everyone, and welcome to Persons and Family Relations. Last time we talked about Articles 5 to 9, and today we will discuss Articles 10 to 13 of the new Civil Code. Let's start with Article 10, which provides that in case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. Article 10, ladies and gentlemen, according to the Code Commission, is necessary so that it may tip the scales in favor of right and justice when the law is doubtful or obscure. It will strengthen, according to the Code Commission, the determination of the courts to avoid an injustice which may apparently be authorized by some way of interpreting the law. It's been said that the law may be harsh, but it is still the law. Hence, the first duty of the judge is to apply the law, whether it be wise or not, whether just or unjust, provided that the law is clear and there is no doubt. It is the sworn duty of the judge to apply the law without fear or favor, to follow its mandate and not to tamper with it. What the law grants, the court cannot deny. That is what the Supreme Court said in the case of Osego versus Anti-Chinese League of the Philippines. But of course, according to the Supreme Court, in case of doubt, the judge should presume that the lawmaking body intended right and justice to prevail. For after all, the Supreme Court said that it has been truly said that we should interpret not by the letter that killeth, but by the Spirit that giveth life. Now we shall discuss Articles 11 and 12 together, starting off with Article 11. Article 11 states that customs which are contrary to law, public order, or public policy shall not be countenanced. Article 12 provides that a custom must be proved as a matter of fact according to the rules of evidence. Dili kayo ni sikat, hindi masyadong sikat sa bar exams or in your quizzes itong concept ng Articles 11 and 12. But for purposes of having an overview of what is the concept of customs, magstorya tagamay dire, okay? Now, in the case of INRE authority to continue the use of firm name CSIP, the Supreme Court defined custom as a rule of conduct formed by repetition of acts uniformly observed as a social rule, legally binding, and obligatory. Okay? The question here would be, what are the requisites before the courts can consider customs? We have to consider the following requisites. The first is a custom must be proved as fact according to the rules of evidence. The custom must be or must not be contrary to law, public order, or public policy. There must be a number of repeated acts. Kay kung kausara na siya gihimo, dili na siya custom, okay? The repeated acts must have been uniformly performed. Dapat dili usara pod ang nagbuhat ana in the community. And there must be a juridical intention to make a rule of conduct. And there must be a sufficient lapse of time. Kay kung gihimo na 1 year 2 years, there's no lapse of time. There's no sufficient lapse of time. And it doesn't become a custom. An act does not become a custom. Okay? You have to remember these requisites in order for the court to consider a particular custom as a matter of fact. Now, the question is, how is this proven? A custom must be proved as a matter of fact. That's according to Article 12, no? A custom must be proved as a matter of fact according to the rules of evidence. Ang pasabot ani, ang ibig sabihin lang naman ito ay courts cannot take judicial notice over a custom. It must be proven through the rules of evidence. Ano ba itong judicial notice? Unsa man ning judicial notice? When you say judicial notice, no, this is actually a concept in evidence that refers to the act of the court in taking cognizance of matters as true or as existing without need of the introduction of evidence, or the authority of the court to accept certain matters as facts even if no evidence of their existence has been presented. The action is often expressed, thus the court takes judicial notice of. Okay? So when we say the court cannot take judicial notice of customs or a particular custom, pasabot lang ani, ibig sabihin lang naman ito, kailangan i-prove muna yan. Okay? This has to be proven first nang nag-o-offer and should not be taken by the court automatically as a proven fact. I-prove muna through the rules of evidence, and when we say evidence, it is actually the means sanctioned by the rules of court of ascertaining in a judicial proceeding the truth respecting a matter of fact. Kay just because ni-exist ang usa ka butang, you have to remember na just because ni-exist ang usa ka butang doesn't really mean nga tinuod na. Mura nagpagpanguya ba nga mag-ingon-ingon kay kag I love you lagi day, I love you lagi day, love kay tika. Manguyab gani kag law student or abogada, no? Just you have to expect nga ingnon gyud ka nag, do you have evidence to prove your claim? Parihara na sa judges, ladies and gentlemen. If a custom is introduced to him, it must be proven first before it can be admitted by the court as a matter of fact. Parihaan ng, let's say, magpa-breed ka o cow, okay, or baka. Customarily, ang arrangement ana, because usara manggoy anak anang baka, no? The baby or the calf, the baby cow, actually goes to the tag-iya of the bayi. And the male cow or the owner of the male cow will only be paid. Let's say 500, 1,000. Depende na siya sa agreement or depende sa custom ana nga particular community. And if naamang gani dispute as to who should get the baby calf, i-present na nimo siya nga customarily ang tag-iya gyud sa bayi ang makakuha sa anak sa baka. Okay? I hope that's clear, ha? Akong balikon customs which are contrary to law, public order, or public policy shall not be countenanced. And a custom, if you will introduce this in court, must be proved as a matter of fact according, of course, to the rules of evidence. Alright? We now move on to Article 13. Article 13 provides that when the laws speak of years, months, days, or nights, it shall be understood that years are of 365 days each, months of 30 days, days of 24 hours, and nights from sunset to sunrise. If months are designated by their name, they shall be computed by the number of days which they respectively have. And in computing a period, the first day shall be excluded and the last day included. Article 13, ladies and gentlemen, speaks of the period as defined by law. This also speaks of how you count the periods. So first we will take on the term year. Year is understood as 365 days in this article, Article 13. Then, a revised administrative code came out, particularly Book 1, Chapter 8, Section 31, and it said that year shall be understood to be 12 calendar months. Month of 30 days unless it refers to a specific calendar month, in which case it shall be computed according to the number of days the specific month contains, day to a day of 24 hours, and night from sunset to sunrise. If you notice, guys, what we have here is a clear conflict. Sa Civil Code manggod, ang year there is 365 days. While in the revised administrative code, ang year is 12 calendar months. Now, the question is this: which between Article 13 of the new Civil Code and Section 31, Chapter 8 of Book 1 of the revised administrative code should govern? In the case of CIR, or Commissioner on Internal Revenue versus Primetown Property, the Supreme Court said that Article 13 has been impliedly repealed by the revised Administrative Code. So what happened in the case of CIR versus Primetown Property was this. Gilbert Yap, the vice chair of Primetown, applied on March 11, 1999 for a refund or credit of income tax which Primetime paid in 1997. So remember, they filed or they applied for a refund on March 11, 1999 for the income tax they paid in 1997. Gilbert Yap claimed that they are entitled to a refund because they suffered losses that year due to the increase of cost of labor and materials. However, despite the losses, they still paid their quarterly income tax and remitted creditable withholding tax from real estate sales to the Bureau of Internal Revenue. Hence, they are now claiming for a refund because according to them, we weren't actually earning anything, but we're still paying taxes. So on May 13, 1999, Revenue Officer Elizabeth Santos required Primetown to submit additional documents to which Primetown actually complied with. However, its claim was not acted upon, which prompted it to file a petition for review in the Court of Tax Appeals on April 14, 2000. The Court of Tax Appeals dismissed the petition as it was filed beyond the 2-year prescriptive period for filing a judicial claim for tax refund according to Section 229 of the NIRC or the National Internal Revenue Code. When we say prescriptive period, this, ladies and gentlemen, is the time limit setting forth the maximum period of time after an event that legal proceedings based on that event may be initiated. In this case, the CTA said, you already went beyond the 2-year prescriptive period, so you can no longer file a judicial claim for tax refund. According to the CTA or the Court of Tax Appeals, the 2-year prescriptive period is equivalent to 730 days pursuant to Article 13 of the new Civil Code. Since Primetime filed its final adjustment return on April 14, 1998, and that year, 2000, was a leap year meaning na ay February 29. The petition was filed 731 days, according to CTA, after Primetown filed its final adjusted refund. Supposedly, the 2-year period should have been 730 days only, and according to CTA, it's already 731 days because you filed it in 2000 and it is a leap year and sobraan siya isa ka adlaw. Hence, according to the CTA, it's beyond the reglementary period. And hence, Primetown appealed to the Court of Appeals, and then the Court of Appeals reversed the decision of the Court of Tax Appeals. And therefore, this appeal to the Supreme Court. So the issue here is whether or not the petition was filed within the 2-year prescriptive period. The conclusion of the Court of Appeals that the respondent, Yap, filed its petition for review in the Court of Tax Appeals within the 2-year prescriptive period provided for in the NIRC or the National Internal Revenue Code is correct. Its basis, however, is not. The rule is that the 2-year prescriptive period is reckoned from the filing of the final adjusted return. But the question now, according to the Supreme Court, is how should the 2-year prescriptive period be computed? The Supreme Court said that, as already quoted, Article 13 of the Civil Code provides that when the law speaks of a year, it is understood to be equivalent to 365 days. In the case of National Marketing Corporation versus Tixon, the Supreme Court ruled that a year is equivalent to 365 days, regardless of whether it is a regular year or a leap year. However, in 1987, Executive Order 292, or the Administrative Code of 1987, was enacted. And Book 1, Chapter 8, Section 3 thereof provides that a year should be understood to be 12 calendar months. Now, the Supreme Court further discussed that a calendar month is a month designated in the calendar without regard to the number of days it may contain. A law may be repealed expressly by a categorical declaration that the law is revoked and abrogated by another, as discussed earlier in our discussion, or impliedly when the provisions of a more recent law cannot be reasonably reconciled with the previous one. Now, you may notice in Book 7, Section 27, in its final provisions, the Supreme Court mentioned that there is a repealing clause which provides that all laws, decrees, orders inconsistent with this code are hereby repealed or modified accordingly. The repealing clause provided for in Section 27 is not an express repealing clause because it fails to identify or designate the laws to be abolished. Thus, the provision specified in Section 27 only impliedly repealed all laws inconsistent with the Administrative Code of 1987. The Supreme Court further said that implied repeals, however, are not favored. An implied repeal must have been clearly and unmistakably intended by the legislature. And the test is whether the subsequent law encompasses entirely the subject matter of the former law and they cannot be logically or reasonably reconciled. This is a bit exhaustive, but it's very important to understand the decision of the Supreme Court with respect to the survival of Article 13, okay? Both Article 13 of the Civil Code and Section 31 of the Administrative Code, particularly Book 1, Chapter 8, deal with the same subject matter. The subject matter in both instances is the computation of legal periods. Under the Civil Code, a year is equivalent to 365 days, whether it be a regular year or a leap year. And under the Administrative Code of 1987, however, a year is composed of 12 calendar months. And needless to state, under the Administrative Code of 1987, the number of days is irrelevant. There obviously exists in this case a manifest incompatibility in the manner of computing legal periods under the Civil Code and that of the Administrative Code. For this reason, we hold that Section 31, Chapter 8, Book 1 ng Supreme Court of the Administrative Code, being the more recent law, governs the computation of legal periods. So, bago na siya ha. When we talk about year, what now governs is the provision of the Administrative Code, which provides that when we talk about year, it shall mean 12 calendar months. So, if we apply Section 31, Chapter 8, Book 1 of the Administrative Code to this case, ng Supreme Court, the 2-year prescriptive period reckoned from the time respondent filed its final adjustment return on April 14, 1988, consisted of 24 calendar months. And it is computed as follows. Makalingaw kaayo ang Supreme Court in this case because they really illustrated the computation by stating therein how to compute the first month, the second month, from year 1 to year 2. So, this is it. And as a conclusion, the Supreme Court therefore hold that the respondent's petition filed on April 14, 2000 was filed on the last day of the 24th calendar month from the day respondent filed its final adjusted return. Hence, it was filed within the reglementary period. So let us never forget that a year is now defined as 12 calendar months. Okay, remember, a year is now defined as 12 calendar months. This is very simple. In short, the Supreme Court really just said nga if we talk about years, we interpret calendar months as how we understand it in its ordinary usage. Example, kung maingon ka og 2 years from now, let's say today is October 12, 2020, 2 years from now, in its ordinary understanding or usage of a calendar month, is October 12, 2022. Okay? You just remember that. A year is 12 calendar months and is understood in its ordinary operation. Say 2 years from today, that's October 12, 2020, is actually October 12, 2022. That's just how simple the Supreme Court reconciled the interpretation of these provisions in Article 13 and that of the Administrative Code. But take note that calendar month in defining a year is not the same month that is used both in the Civil Code and in the Revised Administrative Code. A month is 30 days gihapon. Meaning, if specific ang number of months, you will still count 30 days. Okay? If, let's say, Maria owes Joven a sum of money and Maria promised to pay in 2 months from the execution of the promissory note, say, Maria executed the promissory note on October 8, 2020. Due and demandable na ang obligation ni Maria to Joven after 60 days. Alright? Because a month is equivalent to 30 days and 2 months is 60 days. And the same gihapon yung provision in the days and the nights and so on. So I hope you learned something from our discussion today. Next meeting, we shall be discussing Articles 14 to 20, and please read in advance so that you will have an ample understanding on those provisions when we discuss it next meeting. Thank you very much. Amping.